Welcome to this explainer on a really pivotal, but honestly super misunderstood moment in the New Jersey criminal justice system. We're talking about central judicial processing. Now, for the next few minutes, I want you to just think of me as your personal, seasoned criminal defense attorney. We're going to break down the law, step by step, exactly like you just walked into my office looking for answers.
Because look, it is the single most urgent, terrifying question on literally any new client's mind. You've been arrested in New Jersey. Now what? Your head is probably spinning right now. You're worried about your family, your job, your reputation, and, most importantly, your actual freedom. It's so easy to feel totally paralyzed, but right now, we need to focus on just the immediate next step.
Section 1. The critical first 72 hours. Okay, so the exact second an arrest is made, a fast-moving legal clock basically starts ticking. By New Jersey law, if you are arrested and charged with a serious offense, you absolutely must see a judge within 72 hours. This mandatory first appearance happens at Central Judicial Processing, or CJP for short. Now, depending on your county, it might be called Central Intake Court, but the vital process we're talking about is exactly the same.
So what exactly gets you sent to CJP in the first place? Well, it's generally what the state calls an indictable offense. In New Jersey, this means a first, second, third, or fourth-degree criminal charge. We are talking about really high-stakes, felony-level cases here. These charges carry potential penalties of 6 months or way more in prison or massive fines upward of $15,000. Under the United States Constitution, these severe cases actually entitle you to a full jury trial in Superior Court.
Section 2. Reading your charging complaint. Look, before you even set foot in a courtroom, you have to understand the documents law enforcement handed you. Whether these crucial details are written directly on your complaint or maybe tucked away on a separate sheet, you've got to locate them. Find your court dates, the specific charges leveled against you, and the exact court location. Missing these initial dates is an absolute, unmitigated disaster for your case.
Just to give you a realistic idea of what we actually see day in and day out in these courtrooms, here are some common charges that'll land a defendant right in CJP. We're looking at heavy things like aggravated assault, drug distribution and possession, weapons and gun charges, serious domestic violence cases, and major theft or credit card fraud. These are not simple traffic tickets, okay? These are extremely serious allegations that require a very serious defense.
Section 3. Inside the first appearance.
So, what's it like? What actually happens at CJP? Well, it's mostly an information-gathering event. The judge is going to formally recite all the charges against you so they are perfectly clear on the record. They'll also review your constitutional rights with you. Bail might be set or modified right then and there, though I should note, with modern bail reform, that often takes place at a separate detention hearing now. And finally, if you require one, you'll be given the opportunity to apply for a public defender.
But guys, here is something I really need you to completely understand. There are absolutely no resolutions at this stage. You usually cannot just resolve your case or plead guilty at CJP. Even if a terrified client turns to me and says, "Look, I just want to plead guilty right now to get this over with," these courts generally won't even allow it. CJP is just the starting line. The case has to go through the proper, thorough criminal process.
Section 4. Grand juries and case downgrades.
Right after your CJP hearing, your case is going to face a very critical fork in the road. If it advances in Superior Court, you're facing a grand jury, potential jury trials, and those incredibly severe penalties like actual prison time we talked about earlier. On the flip side, if your defense attorney can successfully provide the right information to get the prosecutor to hold off on an indictment, your case might be downgraded and sent back to municipal court. Municipal court involves significantly less severe penalties, and it's handled locally. Getting a case bumped down like this is a massive, game-changing strategic victory.
Now, if it does stay in Superior Court, the county prosecutor has to present your case to a grand jury to secure an indictment. Have you guys ever heard the old legal saying, "You can indict a ham sandwich"? It's a classic phrase for a reason. Obtaining a grand jury indictment is shockingly easy. The prosecutor literally only needs to provide very basic, totally one-sided information to the grand jury to get them to grant that indictment.
And because an indictment is so incredibly easy for the state to get, early intervention is vital. Before that grand jury ever even convenes, you've got these crucial windows of opportunity. Your case might be scheduled for a pre-indictment conference, what we call a PIC, or an early disposition conference, an EDC. These hearings are basically your golden ticket. They provide you and your attorney a strategic chance to negotiate a quick deal, potentially resolving the whole matter with the least amount of stress and the lightest possible penalties, all before a formal indictment is ever handed down.
When you build all of this into an overall chronological timeline, you can really see just how tight these windows are. Day 1 is your initial arrest. Within 72 hours, bam, you have that mandatory CJP hearing. Following that are those vital pre-indictment PIC or EDC conferences where those deals can be struck. And then only later, if it's still totally unresolved, does the prosecutor actually make their grand jury presentation.
Section 5. Your defense strategy matters.
All right, I am going to give you some very stern practical advice right now, so listen up. Never ever appear at a CJGP's court appearance without a defense attorney. I don't care how trivial the hearing might appear to you or if you think it's just a harmless information-gathering session. Showing up unrepresented puts your actual liberty directly in jeopardy. Period.
And here is exactly why early attorney intervention is just so incredibly powerful. If you retain an attorney early enough, they can sometimes actually waive your appearance at CJP entirely, saving you the hassle. They can proactively hand over information to the prosecutor that could potentially get your charges dismissed right out of the gate. They can aggressively advocate for that municipal court downgrade we discussed. And above all else, they are there to fiercely protect your constitutional rights when you are absolutely most vulnerable.
So, I'll leave you with this provocative question to chew on today. Your liberty is completely at stake. How are you going to build your defense? Do not leave your future to chance, and please don't try to navigate the complex New Jersey criminal justice system alone. Seek counsel, truly understand this CJP process, and take back control of your legal journey. Thanks so much for joining me for this explainer, and I'll see you next time.